Hello, UCAR. Peter Christensen here, coming to you from the CEO's desk, continuing on with the quick-hitting, fast videos about agency. Going to the basics here, covering the fiduciary duties. So we are on confidentiality. We just talked about full disclosure. Now, the two go hand in hand, right? So confidentiality prohibits an agent without permission from disclosing any information given to the agent by the principal that would likely weaken the principal's bargaining position. So your client, if it would weaken their bargaining position, it's confidential information, and you shouldn't give it out without their permission. So a lot of this has to do with strategy, right? Do you disclose there are multiple offers out there? Do you disclose any sort of time crunch? Do you disclose anything unusual about the circumstances, the situation? Well, those all could very well be confidential, deemed confidential, all that information. And so you would need your client's permission before you disclose any of that. And as much as you can think ahead and get their permission, would you like me, if we get multiple offers, to disclose those? Would you like me to do things this way or that way? The more of that you get up front, the better. But don't skip it. Skip that step in a conversation where you are talking to another prospective buyer or agent on the other side, and you say, "Oh boy, this is what's going on. So we sure could use this from you." And you're giving away confidential information without clearing it first with your client. So be careful. Now, there are a couple exceptions to the confidentiality, things that might hurt the bargaining position of the principal, but law doesn't protect as confidential. And those are a defect in the property. So, yeah, clearly, there's really, bad plumbing in this house, but hey, that's not good for the seller. That affects their bargaining position. We'll just keep it secret. Nope, can't do that. You have to disclose that information by law. So that does not fall under the confidentiality protection. And then the client's ability to perform on the contract. That one's maybe a little more ambiguous, but probably prevents you from carrying on a sham transaction, right? The client is not going to, does not have the ability to perform, and you're wasting the other side's time and energy by carrying it on. So those are exceptions, not covered by confidentiality, but everything else that would affect their bargaining position is confidential. Now, does that mean you can never disclose it? No, we just talked about you just have to get permission. So a common one would be multiple offers, right? Remember, it doesn't need to be disclosed by rule unless there's an accepted offer. That has to be disclosed, right? But the existence of multiple offers does not have to be disclosed. It's up to the seller. And so you'd want to get the permission from the seller before you disclose that. So make sure you're just always getting that permission. Error on that side. Thanks for tuning in. Remember, this is not legal advice. This is legal information only. If you need specific legal advice, please contact your attorney.